The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning and welcome to Counsel. And also welcome to all those who are watching on our Supreme Court Live channel. I will now ask Mr. Doug Shima, the clerk of the Kansas Appellate Courts, to please call the 11 a.m. docket.
Thank you, Your Honor. May it please the court. The 11 a.m. docket for Tuesday, October 26, 2021 consists of one case. Appeal number 122253, State of Kansas versus Robert Cash Scheuerman, Martin County, briefs both sides. Your Honor, the appellee petitioner, State of Kansas, has reserved 5 minutes rebuttal time. We are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
Good morning, Your Honors. May it please the court, Michael Duenas, Assistant Solicitor General, appearing on behalf of the state.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Robert Scheuerman, and I'm ready for argument.
Thank you. Mr. Duenas, you may begin your argument.
Thank you, Your Honor. May it please the court. Just by way of the historical background here, Mr. Scheuerman was riding as a passenger in the car, with his girlfriend's car, when the police stopped them. His girlfriend was removed from the car. Mr. Scheuerman remained in the passenger seat. As the police approached, they discovered that Mr. Scheuerman had a gun to his head. And so there was a bit of a standoff for about an hour. Ultimately, Mr. Scheuerman surrendered himself, left the gun in the car, and was arrested. His girlfriend had been taken from the scene. Subsequent to his removal, one of the officers on the scene did an inventory search of the car with anticipation of the car being impounded. And Mr. Scheuerman, when the officer searched the car, he discovered a bag in the car that contained roughly 100 pounds of methamphetamine along with some other drug paraphernalia. And the car was ultimately impounded, I believe. The state charged Mr. Scheuerman initially with possession with intent to distribute more than 100 grams of methamphetamine, but pursuant to agreement with the state, Mr. Scheuerman agreed to a bench trial and stipulated facts. Mr. Scheuerman stipulated in stipulation to possessing more than 1 gram, but less than 3.5 grams of methamphetamine. And the state ultimately reduced he stipulated to possessing more than 3.5, but less than 100 grams. And yet the state had reduced the charge to possessing at least 1 gram, but less than 3.5 grams. At the bench trial, the district judge found him guilty and also denied his motion to suppress the evidence that was taken from the car. On appeal, the Court of Appeals panel found that Mr. Scheuerman did not have standing to suppress the motion or to suppress the evidence found in the car, but it also reversed his conviction, finding that there was insufficient evidence to support his conviction. So that's by way of background. Scheuerman's argument essentially boils down to this, that I possessed even more than what the state charged me with, so the evidence is insufficient for the charge and I get to go free. The Court of Appeals agreed with this because we believe it departed from sufficiency of the evidence analysis and went to a lesser included offense analysis, which is really inapplicable to this case. It tried to sort of extend that analysis to a sufficiency of the evidence, but it's inapplicable. And what's more analogous, we think, is the case of the Charles case. Now, the Charles case isn't exactly on point. It's a stolen property case, but in the Charles case, the state had charged the defendant with misdemeanor theft, even though the value of some of the items that were stolen was over $1,000, which would put him in the category of being felony theft. And he tried to claim the same thing there as is being argued here, that there was insufficient evidence to convict him of misdemeanor theft because the items that he had stolen were worth more than $1,000. And the court said, no, that all personal property has some value. And so even though the state didn't charge you with felony theft, it could charge you rightly with misdemeanor theft, and you're convicted on that because of the value of the personal property. I think another illustration that's apt here would be if a defendant can be convicted of second-degree murder, even if the evidence is sufficient for first-degree murder. And they don't get to walk free and say, well, I can't be convicted of second-degree murder because there's too much evidence. There's evidence of first-degree murder, so it's insufficient to convict me of second-degree murder. We would argue that the state is essentially being penalized here for undercharging Scheuerman and not aligning his stipulation precisely with the lower charge. And, so I think the theory here is that, well, the state could have amended its stipulation to align with the charge. And that's certainly true, although I think that puts the state in the position of either having to get Mr. Scheuerman to stipulate to a falsehood, to stipulate to something less than what he actually possessed, or forcing the state into a position where it has to charge him consistent with the amount that he actually stipulated to. And we don't believe that the statute prescribes this. So I don't think I have more to say on that particular point. That would be our argument against the theory set forth by the Court of Appeals. I might just mention the suppression issue. I think just one point that Scheuerman said that there's no preservation issue here because standing was argued below. Our only argument there would be that what he's raising for the first time here is the social guest doctrine, that it should be extended to automobiles. That was not argued below. And so we don't believe that argument's preserved because it's a new argument. But other than that, I would just stand on the brief. And if there's any questions, I'd be happy to try to address them.
I have a quick question. So this is a unique case because, we're talking about sufficiency of the evidence, and which includes elements. But here, the elements are really part of the statute that talks about the punishment for, what the severity level will be, right?
Correct.
So do we incorporate that as an element of the crime? Is the severity level an element of the crime?
Well, Your Honor, I believe that, there's the reasonable doubt standard that says the state has to prove every element beyond a reasonable doubt. And so certainly one of the elements of the charge, the state reduced the charge to him possessing at least 1 gram, but less than 3.5 grams. And I think the question is, does the evidence support the fact that he possessed that amount? Now, the argument from Mr. Scheuerman is to say, well, he stipulated to possessing more than that, and so he doesn't fit within those strict parameters of more than 1, less than 3.5, and so that element is not met. And our argument is simply to come back and say the evidence for that element is met, again, based on the analogy to the Charles case, that if you possess, more than 3.5, you necessarily logically possess everything below that. And so here it was just a question of, I don't know all the details of what went into it, whether there was just an oversight on the prosecution's case, but they had obtained the stipulation and then reduced the charge. So this is pursuant to agreement. He's getting the benefit of the bargain here to have. So I think it is an element. We're simply saying that the element is met based on his stipulation.
So then, are you actually writing out of the element that there be less than 3.5?
I believe what we're saying is that the category is not, the statute is not so watertight that it compels the stipulation in this case to say, well, he only possessed somewhere between 1 gram and less than, 3.5 grams. That if you don't set the stipulation within those parameters, and in this case, he stipulates to even more, we're just simply saying that doesn't put you outside of that element. The statute doesn't compel that. It doesn't require that. We understand, we would agree that the ranges are mutually exclusive, as he said, but we don't believe they compel insufficiency of the evidence if the defendant is found to have significantly more than that, or even any amount more. So that would be our argument.
Thank you.
Other questions? Thank you. Mr. Hodgkinson?
Thank you, Your Honor. Good morning. My name is Randall Hodgkinson, and I'm appearing today on behalf of Robert Scheuerman. Your Honor, I think it's interesting and important to know what my colleague did not really discuss here, which is the difference between Charles and the instant case, which is Charles and other cases like that were a jury trial, and this was a bench trial on stipulated facts. I think it's interesting, and even in my work on the briefs in this case and preparing for argument, I sometimes had to remind myself, which side am I on? Because members of the court, long members of the court will remember, and new members may or may not know, that I'm a big advocate for juries being able to make decisions about lesser included offenses. And I certainly have other cases, maybe before the court right now. If not, I filed a petition for review yesterday, arguing that, regardless of how much evidence the state has of some amount, that lesser included offense is always appropriate. And so, as I'm like, well, which side am I on here? Do I have a positional conflict? Because on one hand, I have great sympathy for my colleague's argument here that, even if they show 1 million grams, that a jury could reject that evidence and decide that he only had 2 grams or something like that. But the distinction here, and the reason I think that there's not a positional conflict on my part, and the big distinction is this isn't a jury trial. And the fact finder in this case wasn't free to reject the stipulated facts. The longstanding precedent of this court is when parties stipulate to facts, those facts are binding on a judge. They were binding on the district court in this case, and they're binding on the Court of Appeals as it recognized, and they're even binding on this court. So the real question, and I think it's a straightforward question, is when all of these judges, including this court, are bound by the fact that the stipulation that Mr. Scheuerman possessed 3.5 more or grams of methamphetamine, can any reasonable fact finder find that he possessed less than 3.5 grams?
Counsel, if I stipulate to the world that I possess 3 apples, haven't I also stipulated that I possess 1 apple?
No, Your Honor. I mean, 3 is not equal to 1.
So your
3
argument
is more than 1.
in my very simplistic example is the stipulation to possessing 3 apples. What that really means is that, or rather, what I am not stipulating to is possessing 1 and only 1 apple. Because obviously the facts are I do possess 1 apple. I just have 2 extras. But you're saying that what the statute requires is a finding of 1 and only 1, or 2 and only 2. Is
That's
that
right,
a
Your Honor.
fair way to summarize your argument?
The plain language of the statute. I think it says that.
Okay.
And the distinction, again, my colleague sort of trots out this parade of horribles. Well, what about, a first degree premeditated case, but a person was convicted of second degree murder? Is the defendant in that case going to come in and say, well, I can't be convicted of second degree murder? The answer is no, because all of the elements of second degree murder are included in first degree premeditated murder. It would be like robbery and aggravated robbery, where all the elements of the lesser are included in the greater offense. But the Court of Appeals recognized that this isn't a lesser included offense from an element standpoint, because adopting the strict elements test that this court has approved, not all the elements of severity level 3 possession with intent to distribute are in too, because of the difference of the elements. It's still a lesser because it's a lesser degree of the same crime, but there will be a distinction as we think about the ramifications, the evidence, because it's not that sort of nested lesser included offense where all of the elements of the lesser are in the elements of the greater. So the real question here is, does the stipulation matter in this case? The parties stipulated to certain evidence, and unlike Charles, unlike every other jury trial case that this court could possibly review, I think that makes a difference under this court's precedent, that the fact finder cannot find facts contrary to the stipulated evidence. The stipulated evidence in this case was that he possessed 3.5 or more grams. The element of the crime is 1 to less than 3.5 grams. So in order to sustain this verdict, this court would have to say that less than 3.5 grams is the same as more than 3.5 grams. And I just don't think that's right. And I think that's what the Court of Appeals recognized. Is this a weird situation? Yes. Is this I think a fairly unique situation? Yeah. I mean, I think the lesson here is, that, and by the way, when I teach about like review of trials on stipulated facts with students, we talk about why we do these things, what the purpose of it is, et cetera, to be able to preserve issues. But I talk to students and I say, it's still a trial though. The due process clause still applies to this trial. And so regardless of the arguments of the parties, regardless of sort of the intent of the parties even, the due process applies. And one of those aspects of the due process clause is the state is required to prove all the elements of the crime. And in this,
Counsel, under your argument, does it make a difference if the stipulation says at least 3.5 versus not less than 3.5?
it has to fulfill the elements of the crime. The elements of the crime in this case, I think, are 1 gram to less than 3.5 grams. And the stipulation was 3.5 or more grams to less than 100 grams. So
under your argument, it makes no difference under those two stipulations.
That there's not sufficient evidence to find for any court or fact finder in this case, which is the court, to find that there's less than 3.5 grams when the only stipulation binding on the court is that there's 3.5 or more grams.
So your position would put parties in a place where they would have to stipulate to a falsity in order to take advantage of a plea agreement. And there seems to be something just basically wrong with that. Is this a situation where because of that, and us not wanting to suborn perjury, basically, we have somewhat of a different issue than a lack of that, not really focusing on that precision, just to be able to affect the purpose and the intent of the parties while not suborning perjury.
Your Honor, and the state hasn't cited any authority for the idea that it's suborning perjury for parties to stipulate to evidence maybe that isn't even accurate with sort of reality. That's a legal decision we make. And in fact, we know that in plea bargaining all the time, parties agree to factual basis, which may or may not have very much basis in reality. And we don't ever think that those parties are suborning perjury because that they are, maybe agreeing to some lesser charge that we would all look at and say, well, that's not really what happened. But that we understand that that's the way the parties resolve this, and that we will honor that agreement between those. And the same thing with a stipulation. It doesn't necessarily say, I'm saying that this is accurately what happened. It's saying this is how we have decided to resolve this question.
Is that true? Yes, in a proffer of facts for the factual basis for a plea, that is somewhat different, I think, than somebody signing a stipulation, but maybe not.
It's simply a mechanism that we use to resolve for parties to say, we have agreed that these will be the facts that we'll use for this case. Not that and in civil cases, parties stipulate and reach agreements about damages or whatever. And we may go, that's not real. That's just what the parties in this case said they will agree to use as facts for this particular case.
Counsel, if the stipulation had been that they stipulate the defendant had less than 100 grams of methamphetamine, under your argument, that would be sufficient evidence, correct?
For the conviction, for the charge conviction?
Yeah, for the one that went to trial.
Yeah.
For the reduced charge.
If the stipulation said Mr. Scheuerman possessed less than 100 grams, well, I think that would be a different argument, Your Honor, because then I would have to really consider whether or not there was sufficient evidence that he had more than 1 gram, which is also an element of the crime. Whether a stipulation that he possessed less than 100 grams is sufficient to prove that he had more than 1 gram. That's not this issue, but that's the answer to your question, I think. So I can't agree to that, it's a different question.
So does
Um,
does
Go ahead.
sorry, Chief.
Go ahead,
Uh,
just.
Are you suggesting then that the district court is bound by a party stipulation, that there is no discretion to accept, reject, or make alternative findings? Or
Yeah,
just
I think the court's precedent that I cited in my brief says that courts are bound by factual stipulations. They're not bound by legal, by legal agreements, but they are bound by the defendants when they stipulate are bound by factual stipulations. When any party stipulates to facts, that the court and every court is bound by those stipulations. Yes. Now, Your Honor, whether a court can reject a stipulation, I don't know. I mean, I don't know. The court didn't in this case.
But in that event, then your position, I assume, would be then you're left with insufficient evidence.
It's my
to the
position
extent there's any discretion.
and the position that the Court of Appeals found, that on these pretty unique circumstances, that the state stipulated to facts that are inconsistent with what resulted in the charged crime.
I don't want to sound like a broken record, but I come back to the fact that here that is being presented as the evidence for the trier of fact to consider. And to me, that creates a situation where perhaps, I mean, I really haven't thought this through because this thought just occurred to me as we were talking, whether there's even an ethical issue for the attorneys to put forward to a court an untrue fact in a stipulation that is going to be used as the basis for a judgment of the court, which to me is different than, again, in the plea situation where you're not saying, Judge, these are the only facts or these are the binding facts. That rather, anyway, it just seems that that creates a very difficult position for everybody, the parties, the attorneys, and the court.
Your Honor, I haven't researched for the ethics aspects of this in this case. Again, I would assume and believe that it's not different than a plea bargain, that we all recognize in criminal cases, and I'm not a civil expert, but I'm guessing in civil cases that all the time parties come to different kind of settlement agreements and different kind of stipulations about different things in order to resolve litigation that may be consistent or inconsistent with reality. And that's
I think agreements are different than putting evidence in, false evidence in, which is essentially what a stipulation does. So you're knowingly putting false evidence in.
Yeah, I guess I'm not willing or ready to concede that, Your Honor, that it's knowingly putting evidence forward as opposed to saying this is what the parties agree that the facts will be for this case. I understand what you're saying. In fact, in all candor to the court, I mean, I have raised other issues about whether a plea bargain should be vacated because a factual basis was not consistent with reality. I mean, that case may come up, and that it wasn't litigated. We didn't get to litigation to a decision on that. So I understand your point, but I mean, unless this court is, I think, prepared to really say that, and because I don't understand the distinction. That, I mean, a factual basis is you're going to a court and saying, we believe these are the facts of the case. I mean, somebody has to say that. And if it's the idea that, no, that's not just a mechanism for resolving this, that it has to be accurate with your understanding of reality, that's a very different place, I think, Your Honor. And it's, I mean, especially with plea bargaining and understanding that we can resolve claims in expeditious ways, I certainly believe, and it would have believed, that this is just an example of that. My time is out, so I guess I won't move on a lot to the suppression issue, other than to just simply say that, I understand this court in Epperson set forward a pretty categorical rule that passengers don't have standing, and I always use scare quotes when I talk about standing, to raise a Fourth Amendment claim with regard to search of a car. We just asked this court to look at what's happened since 1985. with regard to standing rulings from the United States Supreme Court and even rulings with regard to passengers in the last few years. That when you put those things together, that sort of categorical idea that a passenger can never have standing to make a claim regarding the search of the car doesn't seem tenable any longer. I'll leave it at that because my time is out.
Other questions? Thank you, Mr. Hodgkinson. Mr. Duenas, you reserve 5 minutes.
Thank you, Your Honor. I just want to speak to my opposing counsel's statement about the jury trial being kind of the dispositive fact. There's no reason to suppose in the Charles case that if Charles had stipulated to stealing property in excess of $1,000, the decision would have come out differently. There's just no reason to think that had that been a trial and stipulated facts and there was a stipulation that he had stolen, a door that was worth $1,100, and yet the state wanted to charge him only with misdemeanor theft, that would somehow be reversed due to insufficient evidence. And that's leads me to, I think, my basic point, which is the charge is what's dispositive here. And that's why the Court of Appeals erred in leaving sufficiency of the evidence land and going over to lesser included offenses land. That it doesn't work. It doesn't work for two reasons. One, lesser included offenses only work when you have a jury trial, which we don't have here. But number two, they only work when you have the state charging something, a higher level crime. And then if there's no evidence, there has to be at least some evidence of there being a lower level crime to get the lesser included offense. But here, the state charged the lower crime. That's the charge. And yet, so there was a super sufficiency of the evidence. The stipulation showed, and so the state
Counsel,
didn't.
Can I interrupt you here
Yes.
and ask my same apples analogy question? How should we look at the lower level felony in this case? And again, I'll use my 3 apples. If I stipulate to possessing 3 apples, your argument is, well, that's certainly sufficient for a finding that you possess 2 apples because 3 is more than 2. But is that the right way to look at the statute, or is the statute actually saying the element is 2 and only 2 apples?
I don't believe there's anything in the statute that compels 2 and only 2.
Well, I'll point you to the language, at least 1, but less than 3.5. Because I could see a reading of that language that would be analogous to my 2 and only 2.
I understand that. And my response to it would be to say, I would concede that these are mutually exclusive categories, but I don't believe that they compel, then it would seem to be the case in your supposition that the prosecutor would then be compelled to never undercharge. In other words, if I've got a guy who's saying, or we find him with 10 grams, but in a deal, I want to charge him with I want to charge him greater than 1, less than 3. I can't do that.
When you say they're mutually exclusive, it almost sounds to me like you're giving away your case. Because the way I had viewed these, or at least the way I think we could potentially view these categories, is as nesting dolls. You've got subsection D, which is level 1, which is 100 grams or more, and that's the biggest doll, and then all that sits inside. But you're saying mutually exclusive, not nesting dolls.
I wouldn't say that, Your Honor. I think it's a more narrow. When I say mutually exclusive, I only mean with regard to severity level. So one of these, there's 4 different severity levels here, and you can't have a severity level, 3 if you so they're cabined off by severity level. So that's all I mean by that. I don't mean, as I've said, that means that if you have more evidence and you could prove more evidence than is necessary for the charge.
Well, so what you're saying now is that if you are guilty of the severity level 2 crime, then you, as a matter of logic, are also guilty of the severity level 3 crime.
What I would say is that I would just alter that a bit and say, if the state has evidence of the level 2 crime, they could charge you for the level 2 crime, or they could reduce the charge to the level 3 crime and not be penalized for that decision to say, well, sorry, you've got too much evidence. Like I said, I have more than what you charged me with, so I get to walk. It's, again, I now just to Charles, hey, I had more than $1,000 worth of stolen property, so too bad, I walk.
But if they're mutually exclusive, I mean, that might actually be the state of the law. That's what I'm trying to drive at. Are they mutually exclusive, or does one nest inside of the other?
I guess I would say then that they nest inside of the other, as you're explaining it that way. I only meant to use that terminology to show that, yes, there's these 4 different categories, but I don't, what I would disavow is, I think the way you put it is greater than 1, less than 3.5, and only that. I wouldn't agree with that. And I would say the state didn't ignore the stipulated facts. It matters that they show guilt, but the judge relied on the stipulated facts, and it showed that he possessed at least that much. Certainly the stipulation showed he possessed more than that. I would make one final comment. I think I'm out of time. I don't know if I can finish the point.
You can continue, sir.
I think my final point is just to go with what Mr. Hodgkinson was saying about how, this is just how we work it out and how parties set it up. Well, I think the same could be said in terms of what happened here. I mean, there was a stipulation to these facts before there was the ultimate settlement as to what the agreement was going to be. And so the state was willing to reduce the charge, and that's just how they worked it out. And it didn't force them to engage in a falsehood. Simply said, based on this stipulation, we can still have this lower charge, and he can be convicted on the lower charge and preserve his motion to suppress and all that.
The function of the stipulation in the trial, based upon the stipulated facts, was to preserve the suppression issue, wasn't it?
That's correct.
It didn't have anything to do with what we're talking about now, whether there was, okay, thank you. That's what I thought.
That's all I have, Your Honors. Thank you.
I do have a question.
Okay.
So the issue presented to us, I think Justice Stiegel has really framed it narrowly, which is good. And that is, are we going to go with, is the statute saying 2 and only 2 apples, and they're mutually exclusive, or is it the nesting dolls? And that's that's kind of a complicated question, which requires a lot of analysis. And your position is that, why should the state have to let the defendant go free? But couldn't, I know it brings up Justice Lukert's issue, but, once you amend the charge, why couldn't you at the same time say, okay, well, we better amend the stipulation too, and then this issue wouldn't come up?
It wouldn't come up. I think my argument at that point was just simply to say that you're amending the stipulation to contain a falsehood. In other words, he was found possessing somewhere around 95 grams, and now you're going to have him stipulate that I only possess greater than 1 but less than 3.5, which is not true. He possessed a lot more than that. And so is that a good situation to have him stipulating to something that is a known falsehood to the court for the court to make a factual finding on? So
in your experience, that doesn't ever happen as a in plea agreements?
I can't speak to that. I don't know. I'm not well versed enough in plea agreements as to whether that happens. But I think that the problem here too is that we're dealing with the sufficiency of the evidence claim. The Court of Appeals clearly said this is a sufficiency of the evidence issue, and then they left that off entirely, went over to lesser included offenses, and then came back for a concluding statement saying there wasn't sufficient evidence. Wow. And our argument is to simply say if it's a sufficiency of the evidence claim, then these should be viewed as nesting dolls, and that stipulation shows there was sufficient evidence for a rational fact finder to say,
why couldn't he have just stipulated that I possessed more than 1 gram, period?
I suppose he could have. I don't know. I mean, I have to be honest about that. I suppose he could have. I don't know if there would have been problems of saying I possessed more than 1, and then if he says, but if he doesn't say but less than 3.5, is that going to basically raise the same issue. Well, it's more than one, but it could be a lot more than 3.5, and we just don't know. And so maybe there's insufficient evidence again. I think on a sufficiency claim, it just raises, I think, the same problem.
Let me ask you another question. If the statute said it is illegal to possess one apple, or two, let's say two apples, it's illegal to possess two apples. So your position is that if they prove, or if they stipulate I possess 3 apples, then that's sufficient, even though it pinpoints the 2 apples.
Yes, I mean, I would assume that a legislature that would say it's illegal to possess 2 apples means we're letting you have 1 apple, and anything, and to have 2. Now, again, that might be in the statute. I don't know. I mean, we're dealing with.
No, we're saying that the statute doesn't say 2 or more.
It just says it's illegal to possess 2 apples. And so I assume in the hypothetical, you would be saying, well, you can possess 1 or you can possess 3 or more, and only 2 is right. I don't think that's how these statutes should be read here. I mean, I would think a legislature should then make that clear and say, if it's 2 and only 2, then there's got to be some language indicating that. Otherwise, I think we're reading something into the statute that we ought not to read into it.
Well, even
Ultimately,
okay, sorry, Justin.
no, go ahead. I didn't mean to interrupt you.
I'm done.
I just was going to ask, and as you were wrapping up your argument, is it ultimately that just the function of the standard in which we review the evidence for the sufficiency question, that we draw all reasonable inferences in the light most favorable to the state and all evidence in favor of the state?
I agree with that. I do think that that's the standard, and it's certainly not the standard that would go into a lesser included offense. I mean, lesser included offense just doesn't apply here. It's a different standard, it's different.
It's the opposite standard.
Right. So yes, I think that's the fundamental error here.
Counsel, aren't you also saying that the plain language of KSA 21-5109A, which says, when the same conduct of a defendant may establish the commission of more than one crime under the laws of the state, the defendant may be prosecuted for each of such crimes?
I mean, I don't have the statute in front of me, but I think I would simply say that when the state has what they have here, which is an admission of possessing a certain amount of methamphetamine along with drug paraphernalia, that in a deal, they can certainly opt for a lesser charge and not be dinged for doing that, or not. That's not prohibited, simply because they know or have a stipulation that the defendant possesses more than what they're charging him with at that point. I mean, I mean, if the statute means that, then I think I would agree with that.
The other questions? Thank you to both counsel for your argument. The court will take this appeal under advisement. We are now